SJC-12079, Commonwealth v. Wayne Ruffin.
Good morning, Ms. Deal.
Good morning. May it please the court?
It'll please the
Oh,
court
I'm
in one
sorry.
moment. Don't worry, I'm sure you will please
I'm
the court.
overly eager to please the court.
That's
Yes.
good, that's good. We encourage enthusiasm. All right, now release your enthusiasm.
Thank you, Alex Steele, for Mr. Ruffin. Here we are again, and I'm sure some of you may wish that you had retired a little earlier so you wouldn't have to hear the name Annie Dukin ever again. But so I apologize because today the court is once again tasked with wading through the fallout of a decade of lies, deceit, and fraud on the part of an agent of the Commonwealth. Of course, the question before the court is a little different today, and that's what to do with defendants like Mr. Ruffin, who didn't have Dukin certificates in hand until after they'd entered guilty pleas. To what remedy, if any, are those defendants entitled? I would submit that they are entitled to no less than those defendants whose substances were tested by Ms. Dukin prior to their pleas.
Why?
Well, and let me just address the proverbial elephant in the room right off the bat, which is what's the prejudice? I don't
that's
think,
right.
what is the prejudice? And I would suggest that there are two parts to that. The first part is that he was prejudiced because even if he wasn't relying on the results of the analysis per se, he was relying on the integrity of the process when he entered his plea. And it was never disclosed to him, as it should have been constitutionally, as it should have been under Rule 14. It was never disclosed to him that he had real reason to doubt whether the substances in his case would ever be accurately or honestly tested at the Hinton lab. And that matters. That is material to a defendant's plea. And at the very least, he should have had the opportunity, by way of an evidentiary hearing, to make that showing. Counsel specifically said in her affidavit—
I mean, that an evidentiary hearing to make the showing that, just what you're saying, not whether it affected, she affected his case, but whether knowing what she had done affected his decision to plead.
That's right, because what we're talking about here, we're talking about systemic malfeasance of a magnitude that really we've never seen before. And none of the cases properly address this kind of systemic malfeasance, because in most instances we're talking about the non-disclosure of a piece of exculpatory evidence or the non-disclosure of conduct that is cabined to a particular time. What we have here is the non-disclosure of 10 years or more of fraud, of Annie Dukin testing substances in a way that was improper, of Annie Dukin mishandling substances, of Annie Dukin tampering with substances, of Annie Dukin changing people's signatures on—
Why is it different from the claim that there was exculpatory evidence which the Commonwealth knew and did not disclose? Here, of course, there's no claim of prosecutive misconduct, but she is part of the government. And the defendant saying, you know, if I had actually known that information, that would have materially affected my understanding of the strength of the Commonwealth's case, and I might have done something differently. Is it different from that?
I do think it's different than that. I think it's more than materially affecting the strength of the case. These certificates, this testing, and this is particular to drug cases, it goes to a specific element of the crime, which is the substance itself, right? You can't commit the crime of distribution of a drug unless the Commonwealth can prove beyond a reasonable doubt that it is that drug. So I think it's a little more than just affecting your calculus as to, well, you know, in Ferrara, well, what is the strength of the government's case against me? What is it that the government can and cannot prove based on the evidence that it has? That's not really what this is. I mean, it's that. Also, it's impeachment evidence.
Isn't it certainly the strength of the Commonwealth's ability to prove an element of the crime, which is that it indeed was cocaine?
Pardon me?
Isn't it simply that it goes to the strength of the Commonwealth's case in proving an element, which is that indeed it was cocaine? Or if it was cocaine, I forget what it was here. Was it heroin or cocaine?
Crack cocaine, yeah.
Crack, yeah.
It does go to that, but I think it goes one level deeper, because I think it goes to the factual basis of the plea. So if we take a hypothetical, and if we say, okay, here's a person who is carrying a suitcase with what he believes to be heroin in it, and he's arrested, he's charged with trafficking heroin, and then a month later, he throws in the towel and says, I'm pleading guilty to distribution of heroin. And I think, by the way, we have to recognize that it's kind of a fiction to say that the defendant knows what he did when he pleaded guilty, and that's why he's pleading guilty. The reality of the situation is defendants plead guilty for all kinds of reasons, guilt being one of them. But there are other incentives to plead guilty that don't involve that. And secondarily, we're talking here about something that is actually unknowable to the defendant at the time he pleads without a certificate, which is whether it's a drug or not.
Let me ask you, I'm not sure about the facts here. At the time of the plea, had the government even gotten the drug certificate back? Did anyone know that Andy Dukin was the one who had done the underlying work?
There's no evidence of that.
So everyone was in the dark about what it was that the Commonwealth would or would not be able to prove. You didn't even know if the Commonwealth could get a drug certificate that said it was crack cocaine.
That's correct. In this
Everybody
case,
was operating in the dark about certain facts, and for whatever reason, the plea was done, and unless... So I'm having trouble seeing the prejudice there.
Well, let me finish the hypothetical, and I'll see if we can get back to the prejudice, which I think goes.
Wait, I'm sorry, but going to prejudice, I mean, if you prevail here, all that you would get is an evidentiary hearing where the issue of prejudice would be addressed, correct?
And that's a fair result, frankly. That's a fair result, because this defendant never had the opportunity to say what this evidence might or might not have done.
But he waived it.
Pardon me?
He had a right to wait, and he waived the right.
I'm not sure that you waive the right to withdraw your plea based on something like this. You waive the right to withdraw your plea.
So what if this stuff had never been analyzed?
Then he is out of luck. Although, but here we go back to the hypothetical, which is, and this sort of goes to the newly discovered evidence argument, which is, let's just say, you know, this guy's carrying this briefcase, he gets arrested, and he pleads guilty to distribution of heroin. And then after he pleads guilty, somebody opens the suitcase, tests it, and lo and behold, it's talcum powder. Well, obviously that defendant has the opportunity, whether it's under the doctrine of newly discovered evidence or whether it's a constitutional claim, that defendant hasn't waived the right by pleading guilty to go back into court and say, wait a minute, I need to withdraw my plea because this wasn't heroin. There actually now is no valid factual basis for my plea. And I would submit that it's really no different in this case, in part because we don't know. It could actually be that Mr. Ruffin was not distributing crack cocaine, this was not crack cocaine, and furthermore, she's deprived him of the opportunity of ever being able to prove that. So
But we should not have pleas in drug cases until the certificate arrives.
Well, I don't think that that's necessarily true, because there are certainly cases in which it would be appropriate for a defendant to plead, or reasonable for a defendant to plead
It wasn't reasonable
without
here. I mean, he was convinced that he had the substance that they were accusing him of having.
But his subjective belief that it is that substance doesn't make it that substance, number one. And number two, it goes back to the fact that there are other reasons that defendants plead guilty. Perhaps they're, pretrial confinement, they'd like to get out of that and get into a better situation where there are programs. They're escaping a mandatory minimum by pleading guilty. I mean, there are a number of factors that go into that calculus beyond just, well, I must be guilty, so I'm going to plead guilty.
Well, I thought where you began was, it also is, you need to take waiver into account in a circumstance where the presumption is the system is working the way it's supposed to work. And so if the system is fundamentally flawed in that respect, it's just not the same.
That's exactly right. And it's not so far off base. It's not so far off base to say, we don't accept pleas that are based on fraud. We just don't accept those pleas, and I don't think that's beyond the pale. And I also think that it's actually in line.
That's a bit, I mean, the plea's not based on fraud.
Fair
I
enough.
assume
That may be
he admitted that he possessed
And distributing
cocaine.
That may be slightly hyperbolic. But what I'd also like to say on that point is that it's also not far off from what the Supreme Court said in Kiles versus Whitley, which is that the fact of a suppression itself can be material. And why is it material? It's material because it goes to the integrity of the prosecution. And that is something that the defendant is entitled to know. That's something the defendant in this case was entitled to know. And I would submit that for that reason, he should have been able to withdraw his plea, or at the very least, he was entitled to an evidentiary hearing to make that showing.
All right, thank you. Ms. Yashulis, good morning.
Good morning. May it please the court. Laurie Yashulis for the Commonwealth. Your Honors, under Commonwealth v. Scott, the defendant cannot make his showing under the first Ferrara prong because the defendant cannot show that any misconduct occurred prior to his decision to plead guilty. These
But
substances were
if
not
the-
tested.
But if the presumption is that if she signed a certificate without anything more, that you're entitled to the presumption of egregious misconduct, and she signed this certificate, why doesn't that
substances-
apply?
It does not apply at all in this case. The defendant in this case is no different than any other defendant who makes a decision to plea before the substances have been tested in any other case or before an investigation is complete, let's say. For example, and we have some precedent here.
But the defendant is assuming that everybody is acting on the up and up.
The defendant is making a calculated decision, a voluntary and intelligent decision based on, in this case specifically, that he was charged with 2 undercover purchases of crack cocaine that were field tested, that he was aware of on the day that he entered his plea. So, in the defendant entered a plea, it was part of his calculus in deciding whether or not to plead guilty that day with his attorney, with representation, with knowledge of the circumstantial evidence that would have been admissible at trial, because under Commonwealth v. Marde, it is a presumptively positive field test corroborated by other evidence would be admissible under Marde and under Connolly. So regardless of the certificate in this case, that evidence would have come in. And in this case in particular, the defendant factored that into his calculus in deciding whether to accept a plea agreement whereby he pled guilty to 18 months in the House of Correction, other than, and a dismissal of a school zone charge, which carried a minimum mandatory 2.5 years or 2 years in the House afterwards. He made a calculated decision, just like every other defendant, before an investigation is complete. And in this case, the substances weren't tested until almost 3 months after his plea. He made a decision just like any other defendant in a like position makes a decision. It's a voluntary and intelligent plea. And nothing that happened after the fact, under Scott, could have induced his decision to plead guilty.
But how far do we carry that? I mean, let's imagine a different case in which drugs are found in somebody's home. They plead guilty to it, and then 6 months later it turns out that there's a horrendous police corruption investigation where the detective in that case, as well as in 20 others, are found to have planted drugs.
Well, in that case, you would have probably a newly discovered evidence claim, which, if there was a corruption in his case, are you referring to his case specifically?
There was basically, there were 20 cases, and basically all the cases he touched, especially in the context of having found drugs, potentially now are tainted by the fact that he's known to have planted drugs. Would we say, well, he pled guilty before that was known, and he admitted it, and therefore the conviction stands?
Well, it would depend on other evidence, right? In that case here, we have field tests and undercover buys, but it also would, he may potentially have a newly discovered evidence. Actually, let me take that back. Under a plea agreement, he wouldn't have a claim under newly discovered evidence, but he would have to show that the misconduct, just like we said in Scott, that you're saying that evidence may have been planted after the plea or before the plea, because if it's...
It was planted well, he
it's after the
didn't
plea-
know it was planted. He only discovered it when the police corruption investigation disclosed that there was a dirty cop who was doing this. And after it's all over, it's like, oh dear, we may have tainted cases, 20 tainted cases involving this police detective. Would we just say, well, you pled guilty. You didn't know, when you pled guilty, you had no reason to know that was the case. You admitted it.
Well, it's a little bit different than no reason to know. In this case, we know that Dukin didn't touch the substances until after the plea. So regardless of the certificate issuing, the defendant made his decision to plead guilty. But let me back up for a second. We have a new case, and I'm not sure if this case, if it came up with the appeals court case. I filed a 16L, Commonwealth v. Gorman, which was a 128. And in that case, the substances were tested. And actually, the defendant cites to the Gorman case in her, she is a BMC judge that was on appeal, a BMC court case that was on appeal that's been decided since the filing of our briefs. And in that case, what they said was the misconduct could not have preceded under Scott. Actually, let me take that back. In Gorman, they said that the defendant was entitled to the presumption, even though the substances weren't tested until after his plea, but they said the defendant still could not make the showing on the first Ferrara prong because he could not show that the misconduct preceded his decision to plead guilty. And then we come to a recent case, Commonwealth v. Webb, that was actually his appeals court case, decided 128, that was just decided.
Wait, I'm sorry. So, I mean, now I'm confused. I mean, if there were evidence that Dukin had tested it but hadn't gotten the report till after the plea, it would matter? That if she had tested it on the week before the plea but hadn't gotten around to writing her report till later, and then it was received after, that it would matter?
No, in the Gorman case, she didn't test the substances until after the plea.
I know, and that's the case here too. But I mean, would it matter if she had tested it before, but the report didn't get to anybody until afterward?
I'm not sure under that hypothetical, but actually I would say no, it would not matter because he made the decision before he received the certificate. So just like in this case.
But that goes back to my hypothetical of the planting of drugs. I mean, is it your view that we just always say he pled guilty voluntarily? It's on a voluntariness issue. Didn't affect his decision, so it's a voluntary plea, and the fact that it may turn out that it was planted is something we should ignore.
Well, under Scott, let's say under the voluntariness of the plea and under the analysis that we've done under Scott, what we're saying is we're going to take a look at whether the misconduct induced the plea. And in this case, and in your hypothetical, the misconduct could not have induced the plea. The defendant in your hypothetical pled guilty, not knowing that there may have been planted substances, but he pled guilty on voluntarily and intelligently knowing. There may be an instance of misconduct in that case that may be different, but here we know that the misconduct didn't occur, could not have occurred until after the plea. The defendant made a decision to plea. Under Scott, it does not meet that first Ferrara prong. The Commonwealth doesn't concede, but even under Gorman, if you give him the presumption of misconduct, he still cannot meet his burden of showing that the misconduct induced his decision to plead guilty.
In Justice Gantz's example, however, one could argue that there is now reason to believe that the controlled substances found in my apartment, which resulted in my arrest, that misconduct did, in fact, precede the plea, right? Whereas here, you can't really make that argument, because any misconduct, assuming there was, and we have no idea, occurred long after the plea.
Exactly. So if the drugs were planted prior to the plea, the misconduct occurred prior to the plea. Here it could not have. I cite to.
Think of a plea as a decision to plea is sort of, do I plead or do I go to trial? And clearly, by the time of trial, it would have had to have been tested, and it would have had to have had the certificate.
But that is the decision a defendant makes, and it is more than just an admission.
But he doesn't know that she's a corrupt person. He's assuming that actually the Commonwealth is doing what it's supposed to do and fairly testing.
So his decision was made regardless of the certificates.
He knows that he sold something he believed was cocaine twice to 2 undercover agents.
That was field tested.
That was field tested. He knows that.
He knows that on the day of his plea. He also knows that when he pleads guilty that day, there's an agreed upon by the Commonwealth a dismissal of his school zone charges. And he pleads to concurrent time on 2 separate cases. It is a voluntary and intelligent decision that he makes.
Here's the thing. There was a time pre-Annie Dukin where I think we all lived with this sort of unrealistic view that laboratories didn't make mistakes and that the certificates that were issued were likely to be really pretty unassailable.
Well,
all of that changed once we found out about Annie Dukin. And now I think there is a considerable degree of skepticism about scientific tests more generally, and I think that that's also reflected in cases of the United States Supreme Court where, the fact that it's science doesn't make it unassailable. So this happened at a time, was it before Annie Dukin's misdeeds were known?
9 years ago.
It was,
That was
2007 was, 2007 were the charges and his plea. In fact, the defendant was unconcerned about the certificates and didn't even request them until 2013. So he made his decision.
That's the point that Justice Lenk is making, though.
Correct, but here's the difference. The defendant made this decision regardless of the certificates. Like a lot of defendants in like situations, they assess their case prior to
Well,
the
they
plea.
just assumed that these certificates would be valid and right and correct.
But in this case, there was no testing of it before he decided to plead guilty.
Appreciate that.
So, but even if it, say in Gorman, you give him the presumption, he still can't make a showing of the nexus between her misconduct and his case. Under Scott, he still cannot make that showing under first Farrar prong.
But shouldn't he have a right to show that, to have a hearing on it?
Actually, I'm glad you brought that up, because when the defendant went back for his motion to reconsideration, which was, he filed after this court's decision in Scott, in which Scott said that as a minimum mandatory, he needed to aver that to be the case in an affidavit, the defendant never filed an affidavit. He has never himself made that argument, that had he known of Dukin's misconduct, he would not have pled and would have taken his case to trial, which is a minimum requirement under Scott. And this defendant has never filed an affidavit, even under a motion to reconsideration. So that is fatal to his claim on the second prong. But my argument and the Commonwealth's position is that the defendant made this decision to plead guilty prior to the substances being tested. But even if you were to give him the presumption, he cannot show that anything that occurred by Dukin after the fact could have induced, under the language of Scott, or was material to his decision to plead guilty, and for those reasons, he cannot meet his burden under Scott. And I would urge this court also to look to Ubiera Gonzalez, which I cite to in my brief, which was a Farrar case, but the same analysis. This Gorman case, which I filed as 16L, and also this Commonwealth v. Webb case, which does not have a citation yet. It is a new 128 issued by the appeals court that just came out on April 20th. It's Commonwealth v. Webb, and that case talks about a rejection of a newly discovered argument claim, and also talks about just the fact that the substances were at the Hinton lab without a showing of a nexus between misconduct to the defendant. The claim was rejected that he was entitled to a new trial.
Right,
Thank you,
thank you.
counsel.
Thank you, Your Honor.